Sure. Saper Law bills itself as a law firm representing creative entrepreneurs and innovative business organizations. I started it in 2005, and it's really grown with the types of clients that I have. And so the clients I've had were also startups like my law firm was, and over time they've grown, as has the entrepreneurial community in Chicago, I think, for the types of clients that I have. And those often include the software developers, the website creators, the mom and pop retail stores, and a lot of other web-based businesses that range from clothing to food to medical devices. I think that whereas you see the bigger law firms suffering because their clients are crumbling because of the economy, a law firm like mine is really flourishing because those same companies that are now disintegrating are creating these new entrepreneurs, the ones who've had a corporate, Bob, who's had a corporate job for 50 years and has maybe not that long, 20 years and has a passion for cooking, finally has the opportunity to go pursue that passion because he doesn't have the corporate job holding him down. So it's forcing people to pursue passions and business ideas that they wouldn't have otherwise pursued. And so we're seeing a lot more clients go after those dreams. As far as the kind of businesses I have, I get them at two levels, either the ones that are just starting or the ones who've received their venture capital funding and need a lot of the intellectual property protection or business agreements or litigation in order to continue operation. That because of the nature of the tech community being what it is, meaning a lot of intellectual property capital as opposed to fixed, it's not a restaurant where you need millions of dollars. That was the industry that I targeted first with my business. And that tech community is also really grown, I feel, in the last 5 to 6 years. Intellectual property is the business's primary asset. And to that end, they need to make sure that they're doing what they can to protect those assets. And so when they come to my firm, while I don't handle patent prosecution, I do a lot of copyright filings for code, a lot of licensing agreements, and of course the branding that goes along with any product, the trademarking. And so those are kind of the core areas of our practice. And as businesses are operating online, we're seeing a lot of internet-based litigation as well. Right. So I think that most traditional firms make their money billing hours and hours on long-term litigation. And what I'm seeing now is a lot more, because the areas of law are kind of newer, for example, in the defamation context, we get a lot of little clients that need to know, not to necessarily start a big law firm, but for example, retain us just to find out the identity of someone who's posted something negative online. So rather than, and that petition for discovery, for example, is a far shorter process than a full-fledged lawsuit is. So we will do that. Or, the typical demand letters and cease and desist letters, along with the ICANN proceedings and the WIPO proceedings for domain name disputes. In the context of a domain name dispute, if someone's squatting, you can file a claim in federal court under the Anti-Cyber Squatting Act, or you can pay $1,500 and file a complaint with the WIPO dispute center and expedite the resolution of a domain name transfer. You're not going to get any remedies or monetary awards, but you're going to get the domain name, which in most cases is what you're looking for. So that's a lot cheaper than filing a full-fledged suit. We have clients that are agreeing to mediation, that they'll initiate the suit but quickly go to mediation to resolve the suit. And I think that big law firms need to be creative with the solutions they offer as opposed to the more traditional avenues of getting what you need. That's not always possible, but I think that in a firm like mine, that has been a strong suit of ours, is quickly processing these smaller cases.